Cause them embarrassment. I want to bring in Republican strategist and Madison Firm lead attorney Jonathan Madison. Thank you for being here with us. And first, I want to get your reaction. One of our questions this morning is we expect to see Michael Cohen on the stand this week, but is it rare that prosecutors have not laid out their witness list for this week? To be clear, the defense is going to walk in today to the courtroom and not know who's going to be on the stand? I mean, is that normal operating procedure in a criminal case like this?
You know, it's incredibly rare. It's downright unheard of, to be honest with you. And as a member of the legal profession, I'm shocked that this kind of conduct is being allowed in the courtroom. And to me, it's actually consistent with this judge's sort of pick and choose, guess what's next kind of approach to this trial. I mean, the jurors are obviously confused to some extent about whether and to what extent these are even campaign finance violations, federal election violations, right? And you have to remember that's the entire. That's the only way that the prosecution is going to make their point here is they have to turn Trump's conduct into election finance issues, right? And so I think they failed to do that. But just by the judge allowing certain conduct to occur in the courtroom, it's really confusing the jurors. It's keeping everyone on their toes, and it's keeping this sort of let's see what happens next attitude about what happens in the courtroom. And I got to tell you, it's very off-putting in the legal profession to not have a witness list ahead of any trial, civil, but especially criminal.
It seems professional to me, but I'm not the attorney you are. But let's talk about Judge Merchan, because Trump has already had to pay $9,000 worth of fines. This was last week after Judge Merchan said that he violated the gag order. He's now warning him that if he continues these willful violations of the gag order, he could face incarceratory punishment, jail. Are we really looking at that? Do you think that Judge Merchan is really ready to put the former president of the United States in jail?
You know, I got to tell you, I think he's doing some grandstanding to some extent. And I got to tell you, it's not the first time. This is a big problem, and I tell you why. Donald Trump is a presidential candidate in an election year, right? And you have Biden all over the place making statements however he wants, wherever he wants, using Trump's name. And you're going to tell me that Donald Trump, a presidential candidate, never mind the fact that he's a Republican, forget any of that. He's a presidential candidate in an election year. He can't say anything. You know, and I got to tell you, Cheryl, you know, I've not always been agreeing with the president on any statement, but over the weekend, he accused this administration of being Gestapo. This is the definition of Gestapo. Put a gag order on a presidential candidate. You can't say anything, while the other president gets to say everything. It's ridiculous.
Liz Peek is on set with me. Liz, go ahead.
Yeah, good morning. Do you think that the gag order is going to be grounds for mistrial?
I don't know whether and to what extent a gag order would be grounds for a mistrial, so to speak. Now, I'm hoping it won't come to that, to be honest. I think what the defense is going to do is move for a directed verdict. It's a great question, but I think a directed verdict is really going to put the defense in a strong position here. And just to remind everybody out there, a directed verdict is where the judge basically says, look, any reasonable jury will come to the same conclusion here after they hear all the evidence, especially after they hear Michael Cohen, who everybody already agrees is a liar.
All right. You know, and also, too, I mean, I think the bigger issue here is, and I mentioned this a few moments ago, is that, correct me if I'm wrong, I'm not the lawyer you are, but financial crimes cases are very difficult to prove. But, you know, easier in a civil courtroom than it would be in a criminal courtroom. And I think what's interesting here is that Alvin Bragg, in the first place, ever decided to try this case when other jurisdictions had rejected it based on the evidence that had been presented. They passed. But Alvin Bragg, a New York City district attorney who, we should say, campaigned that he was going to go after the former president, has continued to basically use taxpayer funds and resources to take this case down the line. Do you think that was a mistake on Bragg's part here?
I do. You know, and sort of breaking down the two issues you pointed out there. One, I think this case is ripe for appeal because of that jurisdictional issue. You know, he could have just, you know, held the case in in upstate New York. Instead, he said, well, it has to be here, understanding that there would be a bigger challenge for Trump down in lower Manhattan. But here's the real issue, and here's the other thing you sort of mentioned. The prosecution's case almost rests entirely on proving Trump's motivations, right? His motivations for actually making those payments. Now, if they can't establish, and by the way,
right.
Hope Hicks's testimony blew this issue right open. I mean, it's basically a powder keg leading to an implosion of the entire case on the prosecution's part. But if the prosecution can't establish that Trump's motivations for that payment were for the purpose of manipulating and influencing the election, their case is blown wide open. And as you already know, Hope Hicks already made the statement that he did it for his wife and family, not to influence some election.
Jonathan Madison, great commentary from you this morning, and thank you so much for joining us. We really appreciate it.